Good morning, everyone, and welcome to Zaller Law Group's monthly webinar. Thank you for joining us this morning. I am Vinita Raj, Senior Counsel here at Zaller Law Group, and we also have Yaron Tellis here today, who's a partner at Zaller Law Group. Today, we'll be discussing the ABCs of independent contractors and exempt employees and misclassification pitfalls. Misclassifications occur where employees are inaccurately classified as independent contractors or where employees are wrongfully classified as exempt employees. We will specifically cover who is an independent contractor, the main tests that are used to determine whether a worker is or is not an independent contractor, which include the ABC test and the multi-factor Borello test. We will cover the common exemptions, which include white-collar exemption, inside, outside sales exemptions, and the IT professional exemption. And finally, we will talk about the ramifications for misclassification, both for workers and most importantly, for employers. I will now turn this presentation over to Yaron, who will start us off by discussing who is an independent contractor. But before I move into that, I just wanted to touch or remind everybody that we are SHRM certified and MCLA. So for the information on that, you can email Jeremy Rogers at Zaller Law Group.
Welcome, everyone. Thank you very much for the introduction, Vinita. So let's start with the basics. We've got a lot to cover here today. And so at some point, depending on our pace and timing, we may need to gloss over certain things and not others. But let's see what we can do. So we'll start with the basics. There are two types of workers, employees and independent contractors. Employees are workers employed by a business, person, or government entity. In an employee-employer relationship, the employer generally exercises control over the wages, hours, and working conditions of the employees. Independent contractors, on the other hand, are workers in business for themselves. They're generally free to work on multiple projects at the same time, take jobs on a freelance basis. In many cases, they can choose when, where, and how they perform the work. The distinction between employees and independent contractors is an important one because employees have many legal rights that independent contractors do not. While using an independent contractor can relieve employers of many of the burdens associated with navigating and complying with California and federal employment laws, it's not as easy as merely classifying someone as an independent contractor. In other words, simply identifying or saying a worker is an independent contractor does not make them one under the law. If it were that easy, there would be no need for this webinar. The test to determine whether a worker is an employee or independent contractor has evolved over the years. For purposes of our discussion, we'll focus on the test used for most wage and hour purposes under California law, and we'll go back to 2018 for some background and context. So what was happening in 2018? Well, in the years leading up to 2018, the hiring of workers as independent contractors who were not subject to government rules on minimum wage, overtime, and rest breaks had exploded in those recent years. A 2016 study by economists at Harvard and Princeton universities estimated 12.5 million people were considered independent contractors, which at the time it constituted 8.4% of the US workforce. According to the California's Labor Commissioner, the misclassification of workers as independent contractors cost the state of California roughly $7 billion in lost payroll taxes each year. Next slide. In April 2018, the California Supreme Court issued a landmark decision in the matter of Dynamex Operations West v. Superior Court. In that case, two delivery drivers alleged that Dynamex, a nationwide same-day courier and delivery service, had improperly classified them and other similarly situated drivers as independent contractors. In that case, the drivers were paid a flat fee or percentage of the delivery fee received from the customer, were generally free to set their own schedules, were free to reject or accept jobs assigned by Dynamex, use their own cell phones and vehicles for work, were free to choose their own routes, could perform work for other companies, and were hired for an indefinite period of time. Now, while these facts would likely have weighed in favor of an independent contractor determination under the then relied upon Borello test, which came from the S.G. Borello and Sons, Inc. versus Department of Industrial Relations case, which we will talk about later, the California Supreme Court went in a different direction. The Dynamex court replaced the multi-factor Borello test, which had been in effect since 1989, and embraced a standard that presumes all workers are employees instead of contractors, and places the burden on the entity classifying a worker as an independent contractor of establishing that its classification is proper under the newly adopted ABC test. In September of 2019, Governor Newsom signed Assembly Bill 5 into law, commonly referred to as AB 5, and I'm sure you've heard of it, and that codified the ABC test that was first articulated in Dynamex. AB 5 went into effect beginning January 1, 2020. While AB 5 included exemptions for specific occupations and business relationships, it was confusing for many employers, and in the 9 months that followed its effective date, AB 5 generated significant controversy as California businesses were forced to quickly develop strategies while combating the litany of misclassification civil actions that had emerged. In September 2020, in response to the AB 5 backlash and confusion, Governor Newsom signed AB 2257 into law, which clarified and expanded exemptions to the ABC test. So, what is the ABC test? Under the ABC test, an individual providing labor or services for compensation is presumed to be an employee and not an independent contractor, unless the hiring entity proves all 3 conditions of the ABC test are satisfied. So we start from the default position that everyone is an employee unless proven otherwise, and that proof needs to come from and is bared the burden on the hiring entity. So there's 3 conditions that need to be met. A, the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract, for performance of the work, and in fact. B, the person performs work that is outside the usual course of the hiring entity's business. And C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. Under the ABC test, courts presume workers, let's stay on the previous slide, please, for just a moment. Courts presume workers to be employees. It is up to the hiring entity to prove all 3 conditions of the test. Otherwise, the worker is an employee. And importantly, it does not matter whether the worker wants to be an independent contractor or signed a contract to that effect. And that is what goes back to the portion that talks about it's not just based under the contract for performance, but the work in fact. So the courts are going to actually look at what's happening, not just simply what the parties want. If you're thinking that the use of the ABC test is reason alone to move your business out of California, don't pack your bags just yet. As of December 2023, over 30 other states and the U.S. Department of Labor use the ABC test or something similar to determine worker status. So this is not just unique to California. Next slide. Condition A of the ABC test requires the hiring entity to show that the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. The California Supreme Court in Dynamex explained this condition as follows, that a worker who is subject to the type and degree of control a business typically exercises over employees is considered an employee. Depending on the nature of the work and overall arrangement of the parties, a business need not control the precise manner or details of the work in order to be found to have maintained the necessary control. And the hiring entity must establish that the worker is free of such controls to satisfy condition A of the ABC test. The more the hiring entity exerts control, the more likely the worker will be deemed an employee. So by way of example, in the Western Ports case, a truck driver was found to be an employee because the hiring entity required him to keep his truck clean, report to the dispatch center for assignments, and get prior approvals before taking passengers. The hiring entity could also end the employment relationship if the driver was late, failed to contact dispatch, or violated the trucking company's written policy. In Fleece on Earth versus Department of Employment and Training, knitters and sewers were provided with all the patterns and materials to make children's clothing. Even though the workers were allowed to work at home at their own pace and hours, they were deemed employees because they were given a pattern to follow and were expected to stick to it. In Great Northern Construction versus Department of Labor, a historic restoration specialist set his own schedule, worked without supervision, used his own business debit card to buy materials, and declined the construction company's job offer so that he can work and control his own work. In that case, the worker was deemed an independent contractor, as the court held that the worker was free of such control and the construction company satisfied condition A. Next slide. So let's talk about condition B. Condition B requires the hiring entity to show that the worker performs work that is outside the usual course of the hiring entity's business. This is straightforward and essentially means that if you are hiring someone to assist you in your primary business activity, it's unlikely they can be considered an independent contractor. These workers would ordinarily be viewed by others as employees of the company. This is probably one of the, I think, of the three in the ABC test, the toughest to escape for some industries. Some examples quickly would be that a bakery that hires cake decorators to work on its customized cakes on a regular basis would be hiring employees, whereas that bakery that hires a plumber to repair a leak in the store's bathroom would be hiring an independent contractor. So when evaluating this condition, you should ask yourself whether the worker being assessed performs services that are already commonly done at your business, or it's similar to the work already being done by your other employees. If the answer to that question is yes, it's more likely than not that that worker is going to be deemed an employee and not an independent contractor. Next slide. The third of the ABC is condition C. This prong requires that the hiring entity show the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. The phrase independent contractor is generally used to describe workers who have made the decision to go into business for themselves. As noted by the court in Dynamex, going into business for oneself often involves incorporating as a business, advertising, obtaining any necessary business licenses, registrations, making offers to provide business services to the general public. The hiring entity must prove the independent business operation is actually in existence at the time the work is performed. The fact that the business operation could come into existence in the future, or that the hiring entity did not prevent the worker from engaging in such a business, is not sufficient. Some examples. A construction company hired siding installers who provided their own tools. However, the installers had no instrumentalities of a business, like a business location or a business phone number, and did not receive income from anyone other than the construction company. In that instance, the court held that the siding installers were employees, not independent contractors. In another example, a group of auto repair appraisers had home offices and business cards, their own licenses to operate, provided their own equipment, and were soliciting business from other companies. The company that hired them was not necessarily their employer solely because the appraisers had not worked for any other business. And in that instance, they were not deemed employees, but instead the independent contractor classification held up. Next slide. California's law contains dozens of complicated exceptions to the ABC test for various industries and professions. And in fact, there's over 100 types of workers exempted from the application of the ABC test. If an exemption applies, then courts will apply the test specified in that statutory exception. The following are just some examples of exceptions that are found throughout the code, and these are exceptions to the ABC test. Physicians, surgeons, dentists, podiatrists, psychologists, veterinarians, lawyers, insurance brokers, private investigators, accountants, registered security brokers, dealers, and investment advisors, real estate licensees, direct sales salespersons, commercial fishermen, business-to-business contractors, referral agency and service providers, construction industry subcontractors, and many more. And let's not forget the most recently exempted group of workers are the app-based drivers, and that was the result of Proposition 22. That particular exemption is not just an exemption from the ABC test, but an exemption entirely from both ABC and Borrello and any fallback. They are, as long as they satisfy the conditions that are set forth in the law, they are independent contractors. Okay, so what does this mean? Next slide. What happens if an exemption applies? If one of the exemptions to the ABC test applies, the determination of a worker's status as an employee or independent contractor will likely be based, in whole or in part, on the Borrello test, which Vanita will cover in the next section. I use the phrase in whole or in part because some of these exceptions to the ABC test not only identify the use of the Borrello test to determine worker status, but also have additional criteria that must be satisfied. So in other words, just simply satisfying the Borrello test may not be enough for some of these exemptions. By way of example, the business-to-business contractor exemption states, if an individual acting as a sole proprietor or a business entity formed as a partnership, limited liability company, limited liability partnership, or corporation contracts to provide services to another such business or to a public agency or quasi-public corporation, the determination of employee or independent contractor status of the business service provider shall be governed by Borrello if the contracting business demonstrates that all of the following criteria are satisfied. What is that following criteria? Next slide. The exemption from the ABC test only applies if that contracting business demonstrates that it has satisfied 12 separately listed requirements. Now for fun, I've included the 12 requirements on this one slide. These are the requirements, again, under the business-to-business contractor exemption. I know it's hard to read, but I wanted to fit it all on one slide, and we can skim through the highlights. And you'll note that many overlap with some of the requirements of both the ABC test and the Borello test, which you'll hear about shortly. So by way of example, the first one is about being free from the control and direction of the contracting business. Requirement number 2 talks about that the service provider is providing services directly to the contracting business and not to the customers themselves. Number 3 requires a contract in writing that specifies certain things such as the amount being paid, the applicable rate, the due date of when payments are going to be due. Number 4 requires a business license or business tax registration to the extent that that is required in that jurisdiction. Item 5 requires that there's a separate business location of the service provider separate from the hiring entity. 6 requires that the service provider customarily is engaged in an independently established business of the same nature. In other words, they're doing this work for others, not just for you. Number 7 is requires that they can contract with other businesses. In other words, this can't be an exclusive relationship and that they're not allowed to work for others. Number 8 is that this particular service provider is advertising and holding itself out to the public to provide the same or similar services. Again, that this is not just between you and the service provider, but that they are conducting this business and providing it to others and actively engaged in holding themselves out or advertising or marketing such business. Number 9, no surprise, is that the service provider provides its own tools, vehicles, equipment, and so forth. 10 is that they can negotiate their own rates. 11 is that they can set their own hours and location of the work. And 12 is lastly that they're not performing work essentially in the construction trade, not something that does not require a license under the Contractor State License Board. So I ran through those requirements. Those apply specifically to the business-to-business contractor exemption, and I use that to be illustrative of the fact that various exemptions may have various criteria to satisfy that are in addition to satisfying the Borello test. And I'll now turn it over to Vinita, who will talk to you about the Borello test.
Thank you, Yaron. So what is the Borello test? As Yaron already mentioned, while the ABC test is the primary test for worker classification in California, there are certain situations where that test will not apply. And in those cases, the determination is made under another set of criteria, which we call the Borello test. This test applies a complex multifactorial approach. It requires consideration of all potentially relevant factors, but focuses, however, on the level of control the employer has over the work and the work performed. This, you probably notice that this is also an overriding factor with the ABC test and the business-to-business exemption. Put another way, whether the potential employer has control over the manner and means of accomplishing the result desired. While the right of control must be considered with the other factors, it is essentially considered the most important factor of the Borello test. With that, we now get into what are the Borello factors. I have 13 factors, narrowed it down to 13. The first one is the employer right to control, whether the potential employer has control over the manner and means of accomplishing the result desired. And this basically turns on how much or how significant of the employer's control is on how the work is done. Also, if the potential employer has the right to control the details of the work performance, regardless of whether or not that right is exercised, the person performing the services will likely be deemed to be an employee. The second factor is worker independence. This basically means whether the worker performing the services holds themselves out as being engaged in an occupation or business that's distinct from that of the employer. Third factor is worker integration, whether the work is regular or integral part of the employer's business. The fourth factor is the tools and workplace. Does the employer or the worker supply the instrumentalities, tools, and the place that the work is being done? Fifth factor is workers' investment, whether the worker has invested in the business, such as, again, buying their own equipment, materials for the task that they're going to be doing. Sixth is the specialized skill of the services that are being provided. Seventh is the whether the work is usually done under the direction of the employer or by the specialist or the worker without any supervision. The eighth factor is the worker's risk and reward. Is there opportunity for the worker to have profit or loss depending on how they manage their, depending on their skill sets? Ninth factor is the duration and permanence of the work. So the length of the time for which the services are performed, the degree of permanence of the working relationship. Is the work short-term or ongoing? And is the relationship expected to be long-term? The payment of method, is the worker paid biweekly, weekly, or is it based on completion of project or the job? 11th is the authority to hire. Does the worker have the ability to hire their own employees? 12th factor is the termination process, whether the employer has the right to fire or whether the termination gives rise to an action for breach of a contract. And finally, perception of the relationship, whether or not the worker and the potential employer believe they are creating an employer-employee relationship. However, do note that this may be relevant, but the legal determination of the employment status is not based on whether the parties believe that they are employer-employee relationship. Next slide, please. So with the Borello factors, no single factor dominates the Borello test. All relevant aspects must be weighed. But keep in mind that the level of control the employer has is a pretty important factor. Courts have emphasized different factors in the Borello test depending on the circumstances. For example, where the employer does not control the work details, so this is where the control didn't really matter, but there was still an employer-employee relationship. And in those circumstances, the employer retained control over the operation as a whole. The worker's duties were an integral part of the operation, and the nature of the work makes detailed control unnecessary. When does the Borello test apply? Next slide, please. As Yaron mentioned, there are exceptions to the ABC test, which is codified in the Labor Code. So the Labor Code sets forth express exceptions and lists the occupations where the ABC test does not apply and the Borello test applies. Then there are other circumstances where the court may determine that the ABC test cannot apply for reasons other than what's expressly stated in the Labor Code. For example, there may be a separate law, a separate applicable federal law that preempts the applicability of the ABC test. And then there's other occupations of contracting relationships, business to business exception that Yaron briefly touched on. In slide 24 and 25, I've listed the specific jobs that are exempted from the ABC test. Now, this is just the specific exemptions. However, as Yaron already mentioned, there are other exceptions that apply that then determine whether or not the Borrello test applies. But before the Borrello test applies, whether you must meet other requirements before you even get to the Borrello test. So in the interest of time, I've listed the express exemption, but I'm not going to cover that in detail here. And then with that, we will now get into the exemptions. And Yaron will start us off with the white collar exemptions.
And before we do that, I just wanted to just quickly, mention that as Vanita had indicated, well, the Borrello test has like 13 factors. It may seem onerous, but as a business owner or as an employer, the Borrello test is your friend, because as Vanita had indicated, there is no single factor that controls the determination. And so it is a multi-factor test that requires consideration of all the relevant facts for all of the factors. And so a few bad ones, pardon the phraseology, but a few bad ones that go against you isn't dispositive. Whereas the ABC test may only have 3 prongs to it, but all 3 need to be met, and those are strict. There is no balancing or waiving, or you're strong on 2 but weak on 1. You have to satisfy all 3 to get it, and which is why the Borrello test, when it can be applicable, is more helpful than harmful. Okay. So white collar exemptions. Generally, exempt employees are your key personnel who possess management and decision-making responsibilities. An exempt employee is normally an executive, administrative, or professional employee, and these are the most common exemptions, often referred to as white-collar exemptions, but there are others. Provisions of sections 3 through 12 of the wage orders do not apply to exempt employees, notably overtime, minimum wage, time record requirements, meal periods, and rest periods. In order for California employees to be exempt, they must generally meet a minimum salary requirement and strict job duties tests particular to each exemption. The salary test, you can move to the next slide. Sorry about that. The salary test is the same for all the white collar exemptions, professional, administrative, and executive. And earning a certain salary is only one of the requirements that must be met for an employee to be exempt from overtime or others under the white collar exemptions. And these requirements, 2 of the prongs of the requirement are the salary test, and then there's the duties test. So as I said, the salary test has 2 prongs, a salary level test and a salary basis test. This next slide. The salary level test requires that the employee earns a monthly salary equivalent to no less than 2 times the state minimum wage for full-time employment. California Labor Code requires that to satisfy the salary level test, an employee sorry about that, technical glitch. So when we're talking about full-time employment, what does that mean? Full-time employment means employment in which an employee is employed for 40 hours a week. Just for your edification, full-time employment annualized amounts to 2,080 hours, which is 40 hours per week for 52 weeks. This is also helpful if you want to reverse engineer an annual salary to determine a salaried employee's hourly rate. The salary test is easy to determine. Identify the applicable minimum wage and just do the math. Either you're paying the minimum salary requirement or you're not. So that determination is easy. So let's walk through one very quickly. Effective January 1 of this year, the minimum wage for California is $16. Based on that, the minimum salary threshold to satisfy the minimum salary requirement for the exemption is $66,560 per year. How do we get that? We take the state minimum wage of $16 an hour, multiply it by 2,080 hours, which, as we talked about before, is the equivalent of 40 hours a week for 52 weeks. And then we multiply it by 2 because, as you may recall, it needs to be twice the state minimum wage. And so that's how you end up with $66,560 per year. Or if you're calculating it by month, it's $5,546.67. So now remember, this salary test is based on the state minimum wage, not the federal minimum wage, which is much lower, and not any local city or county ordinance minimum wage requirement, which oftentimes in California is much higher. There is a caveat here. Effective April 1 of 2024, those that are in the hospitality or restaurant space already know, but the applicable minimum wage for the fast food employees covered under this new law that went into effect April 1 is $20 per hour. And that particular statute does identify that $20 per hour increase in the minimum wage as being the equivalent of the state minimum for that industry, which means then that the minimum salary threshold for fast food restaurant employees that are classified as exempt is $83,200. That's an important note to that. All right, next slide. The salary basis test requires that the employee must be paid a predetermined and fixed salary that is not subject to reduction because of variations in the quality or quantity of work performed. So as the court explained in the Negri versus Koenig and Associates decision, while wage orders do not define salary, the term salary is generally understood to be a fixed rate of pay as distinguished from an hourly wage. In the Negri case, the court held that because defendant stipulated that it never paid plaintiff a guaranteed salary, and that if plaintiff worked fewer claims, he made less money. Therefore, the plaintiff was not paid a predetermined amount that was not subject to reduction based upon the quantity of work performed. Since plaintiff was not paid a salary, by that definition, defendant did not prove that the employee qualified as an administrative exempt employee under the wage orders. Next slide. The case of Helix Energy was decided in early 2023, I believe February 22nd, for those that care. In that case, the U.S. Supreme Court examined whether a high-earning employee is compensated on a salary basis for purposes of the salary basis test when that employee received a paycheck based solely on a daily rate. In that instance, he received a certain amount if he worked 1 day in a week, twice as much for 2 days, 3 times as much for 3 days, and so on. Plaintiff claimed that because he was paid on a daily basis, he did not meet the salary basis requirement to be exempt, and therefore should be paid for his overtime. The employer argued that plaintiff's daily pay exceeded the federal weekly pay requirement, $455 per week at the time, for exempt employees, and therefore he should be exempt because he was always paid over the federal requirement for each week he worked. Next slide. The High Court held in favor of the employee that the employer did not pay on a salary basis. The court said that Congress has repeatedly rejected efforts to categorically exempt all highly paid employees from overtime requirements. As the court explained, a daily rate worker's weekly pay is always a function of how many days he has labored. It can be calculated only by counting those days once the week is over, not, as the regulations require, by ignoring that number and paying a predetermined amount. The court noted that the definition of salary refers to fixed compensation regularly paid as by the year, quarter, month, or week, which is distinguishable from wages for pay given for labor at short stated intervals. The takeaway is a day rate is not a salary, even if the rate would exceed the minimum salary requirements. Next slide. The salary test required for overtime exemptions provides that an employee must be paid a full weekly salary for any week in which any work is performed. If an employee works any part of a day, they must also be paid in full. No salary deduction is allowed. When classifying an employee as exempt, it is important that you avoid deductions from an employee's salary that may jeopardize that exemption status. Any improper deduction from an employee's salary may render the employee non-exempt, and the employer would be subject to overtime and meal and rest break issues, etc. So what are some impermissible deductions? I've got a list here that includes deductions for quantity or quality of work performed, unavailability because of operational needs, disciplinary reasons, jury duty, witness duty, military duty, cannot make deductions for absences caused by the employer where the employee is ready, willing, and able to work, partial day absences, though there are exceptions, and then deductions from pay as a penalty for workplace rule violations. It's always a good idea to check with counsel before making any deductions. I just remind that to you. These are not intended to be exhaustive lists of every opportunity and possibility for deductions. But these are lists of impermissible deductions. Let's take a look at some permitted deductions. Next slide. Certain limited deductions are permitted for an exempt employee. And they include, full day absences for personal reasons other than sickness or disability. You can prorate in full day increments for first and last week of employment when an employee does not work the full week. Time off for under CFRA or FMLA. Full day absences under a paid leave policy, plan, or practice. Deductions from accrued vacation or PTO time for partial day absences, and full day absences imposed as unpaid disciplinary suspensions, one or more full days imposed in good faith for violation of written policy or workplace conduct rules such as sexual harassment. But again, check with counsel before making these deductions. Next slide. So now let's talk about, we've talked about the salary tests. We're going to jump to the duties tests for exempt, white collar exemptions.
Yaron, before you move on, I just wanted to clarify something. The permissible and impermissible deductions, the purpose that we covered is to, if you start making these impermissible deductions from, let's say, your exempt employee salaries, you're then risking the exemption, risking the loss of the exemption. So the employee can argue because of these impermissible deductions, you are treating them as a non-exempt employee versus an exempt employee.
Exactly. Thank you. Okay. Assuming that you've satisfied the salary test, now you need to satisfy the duties test for the exemption classification. So under the executive exemption, there are 5 criteria that must be met. 1, duties and responsibilities involve the management of the enterprise in which the employee is employed or of a customarily recognized department or subdivision thereof. 2, customarily and regularly directs the work of 2 or more employees therein. 3, has the authority to hire or fire other employees or whose suggestions and recommendations as to the hiring or firing and as to the advancement and promotion or any other change of status of other employees will be given particular weight. 4, customarily and regularly exercises discretion and independent judgment. And the 5th criteria is that he or she is primarily engaged in duties which meet the test of the exemption. Next slide. So when we say primarily engaged in duties which meet the test of the exemption, primarily means more than 1/2 of the employee's work time. In other words, more than 50%, even if that more is 50.1%, just needs to be more than half. Exempt work shall include, for example, all work that is directly and closely related to exempt work and work which is properly viewed as a means for carrying out exempt functions. Here's a quote from the Labor Commissioner's view. In order to meet the criteria of a managerial employee, one must be more than merely a supervisor of 2 or more employees. The managerial exempt employee must be in charge of the unit, not simply participate in the management of the unit. An employee who merely applies his or her memory in following prescribed procedures or determining which required procedure out of the company manual to follow is not exercising discretion and independent judgment. Next slide, please. It can be tricky for certain roles like managers because these roles typically perform both non-exempt and exempt duties. So things to consider, of course, is that you need to make sure that the exempt duties are more than 50% of the time being spent, and that's typically viewed in a work week. So you don't need to micromanage every minute or each day, but in the aggregate for a work week is how that's going to be viewed. Work performed by a non-exempt employee is generally non-exempt work when performed by the supervisor. Regulations do not recognize hybrid activities having both exempt and non-exempt aspects. Identical tasks may be exempt or non-exempt, depending on the manager's purpose in engaging in the task or the task's role in the work of the organization. In large retail establishments, when certain tasks are customarily assigned to non-exempt employees, the performance of that work by a manager is non-exempt. So those are just some factors to consider when determining whether or not the work being performed is exempt or non-exempt. Next slide. So here's just an example of some duties that are characterized as exempt versus non-exempt for the restaurant space, okay? So in that particular industry, exempt duties may include setting and adjusting pay and work hours, interviewing, hiring, disciplining, and training employees, evaluating employee efficiency and productivity, handling employee complaints, managing safety of employees, controlling flow and distribution of merchandise, materials, and supplies, managing and directing kitchen staff. So in that same restaurant, the following duties would likely be non-exempt. Inventory and replenishing stock pursuant to a set formula, cashier, taking customer orders, bussing tables, preparing food and drinks, serving and packaging food. And obviously, these are samples for that particular industry. They vary for every industry, but this hopefully gives you a sense of how they would break down and things to consider. Next slide. Let's talk about the administrative exemption. So the following criteria must be met to satisfy the administrative exemption. One, duties and responsibilities involve the performance of office or non-manual work directly related to management policies or general business operations of the employer or the employer's customers. And it customarily and regularly exercises discretion and independent judgment. And again, you're going to see some of these overlap between all the exemptions. They're similar or maybe similar. So in addition to those, to satisfy the administrative exemption, you must also meet one of the following criteria. Next slide. Of which there's three. So either regularly and directly assists a proprietor or an employee employed in a bona fide executive or administrative capacity, or performs under only general supervision work along specialized or technical lines requiring special training, experience, or knowledge, or executes under only general supervision, special assignments, and tasks. So these three, you don't have to satisfy all of them. You just need to satisfy at least one of them to maintain the administrative exemption. Next slide. Of course, as before, and as will be with any of these exemptions, the employee needs to be primarily engaged in the duties which meet the test of the exemption. So for administrative exemption, common examples of positions, and again, the law does not take into account the title that you give the employee. They really look at the actual duties. But here are titles of employees with the assumption that these duties are satisfy the exempt criteria, but typically executive and administrative assistants, tax and insurance experts, purchasing agents, personnel directors, account executives. These are just examples. And examples of exempt duties under the administrative exemption include advising management, planning, negotiating, representing the company, purchasing materials and supplies, promoting sales, researching business opportunities, analyzing business data, determining company and or personnel policies. And these are just some examples. By no stretch are these exhaustive. Next slide. Labor Commissioner's view. Here's another quote. Regarding the requirement for the exemption to apply that the employees customarily and regularly exercises discretion and independent judgment, this phrase means the comparison and evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. The employee must have the authority or power to make an independent choice free from immediate direction or supervision and with respect to matters of significance. Next slide. I'm going to try and hurry this along. I see that we are running short on time. Last of the white collar exemptions is the professional exemption. You must meet one of the following criteria. You need to be licensed or certified by the state of California and primarily engaged in the practice of one of the following recognized professions: law, medicine, dentistry, optometry, architecture, engineering, teaching, or accounting, or primarily engaged in an occupation commonly recognized as a learned or artistic profession. Next slide. Unlicensed professionals may be exempt as learned professionals. Work requiring knowledge of an advanced type in a field or science or learning, customarily acquired by a prolonged course of specialized intellectual instruction and study, as distinguished from a general academic education. That is how we look at what a learned professional is. Labor Commissioner has noted that an advanced academic degree above the bachelor level is a standard prerequisite. For example, the Ninth Circuit Court of Appeals found that an unlicensed accountant could still be classified as exempt if they met the various requirements for a learned professional. Next slide. Artistic profession, work that is original and creative in character in a recognized field of artistic endeavor, as opposed to work which can be produced by a person endowed with general manual or intellectual ability and training, and the result of which depends primarily on the invention, imagination, or talent of the employee, and work is predominantly intellectual and varied in character, as opposed to routine, mental, manual, mechanical, or physical work, and is of such character that the output produced or the result accomplished cannot be standardized in relation to a given period of time. The Department of Labor Standards Enforcement has recognized fields include music, writing, theater, and the plastic and graphic arts. These all fall under the artistic profession. Whether a licensed, learned, or artistic professional, any one of these positions must also be customarily and regularly exercising discretion and independent judgment in the performance of the duties. So as the Department of Labor Standards Enforcement had noted, the employee must have the authority or power to make an independent choice, free from immediate direction or supervision, and with respect to matters of significance, similar to what we talked about before. And like we said, a lot of these tend to overlap between the white-collar exemptions. All right, at this point, I'll hand it over to Vanita to talk about some of the other exemptions.
Thank you, Aaron. So I will quickly cover some of the other exemptions. So these include sales or commissioned employee exemptions. First is the inside sales, also known as the retail sales employee exemption. The requirements of this exemption are the employee's principal function is selling of a product or service. Compensation for the sales is a percentage of the price of the product or service that is sold itself. Earnings exceed 1.5 times the minimum wage, and more than half of the employee's compensation comes from commissions. Note that the wage payments for the employees and that the employee is entitled to must come from the sales that they make and must make up more than half, more than 50% of the employee's compensation. And any discretionary payment that an employer chooses to pay is not a commission, even if it is computed on a percentage of sales or profit basis. So what exemption does inside sales exemption provide? It's only overtime. So this is not unlike the other exemptions that Yaron covered. This is limited exemptions. The next slide, to satisfy the minimum wage requirement, they must receive in each paycheck an amount that exceeds 1.5 times the minimum wage, and the employer cannot reassign wages from different pay periods. In the next two slides, in the next slide, 49, if both are satisfied, the employee would be exempt from overtime. So the earnings paid per period exceed 1.5 times, and then the compensation represents, more than half of the compensation represents commissions. Note that if there is a guaranteed draw against commissions, DLSA or the court considers that earnings are not in fact commissions, but instead a salary. And in that case, this exemption may not apply. That employee would be due overtime pay unless some other exemption applies. Next, we have the outside sales exemption. The next few slides cover that. And then the final exemption at slide 55 and 56 is for the computer software professional exemption that has 4 main criteria. And most importantly is the hourly rate or the minimum annual salary of $115,763.35. We're out of time, so we will not be able to get into the ramifications of misclassification. which start at slide 60, I believe. So you can see the chart that we have prepared, actually 58, that outline the benefits that an employee is entitled to, or the entitlements for an employee versus an independent contractor, which illustrates what the differences are with respect to wage and hour laws for the most part. And then, if there is a misclassification, there are significant penalties for an employer. If you misclassify an employee as an independent contractor, you didn't pay workers' compensation benefits for them, and there are other wage and hour as well as tax and other benefits related penalties that the employer may be subject to. So with that, we end our presentation today. We hope that you found it helpful. And if you have any questions, as always, please feel free to reach out to us. And at the end of the PowerPoint, it has our information. And then again, for the SHRM and MCLE certification information, you can email Jeremy Rogers at jrogers@zallerlaw.com. Thank you very much.